it is fast. When it doesn't, now in court of appeal say, oh, it's all right to be fast. But in TCT, it's not. I mean, it's not fine to be.
Was this slow?
Fast.
Was this slow in the case of the federal government against Saraki at the CCT?
CCT. Well, I will say it has gone within the normal ranking because it has even gone on appeal. It took time. Remember 2016 to 2018 when judgment was given. But look, the application was filed. I understand was filed. I mean, one day, the next day they slapped the Attorney General, and then the day after, they now ask the Attorney General, come to court.
Okay. All right. Let me bring in our colleague Ayo. He's in Lagos. Ayo, go ahead with your question.
Thank you, Chams. I wanted to, I'd like to begin with the SAN, Mr. Chukwuma. In 2013, Justice Onnoghen, sitting at the Supreme Court, was said to have, was quoted to have quoted paragraph 12 of the 5th schedule of the 1999 Constitution, and says any allegation that a public officer has committed a breach of or has not complied with the provisions of the code shall be made to the Code of Conduct Bureau. Further down, he says the tribunal has to the exclusion of other courts, the tribunal to the exclusion of other courts is also empowered to impose any punishment as specified under subparagraphs 2A, B, and C of paragraph 18, as provided in subparagraphs this and that, while appeals shall lie as of right from such decisions to the Court of Appeal. Simply put, he says, to tackle any violation of the code starts before the Code of Conduct, Tribunal, to the court below on appeal and on a further appeal therefrom to this court. That's sounding to me like Justice Onnoghen, as far back as 2013, already validated the fact that the Code of Conduct is superior to any other court as long as far as the Code of Conduct requirements are concerned. So what exactly is, I think that's where this should have begun.
What he's saying, those that are supposed to be before the tribunal has exclusive power. He's not saying when you bring the president, a sitting president or a sitting governor, the tribunal has exclusive power. No. So, if the tribunal cannot try a sitting president, a sitting governor, a sitting vice president, then under section 153 and schedule 3 and the section 292, the CCT doesn't have the power.
He's a public officer. Why don't we let's look at it from that perspective.
Today,
he is a public officer before he's a judicial officer. Isn't that the order?
Sleeping when he defined a judicial officer separate and defined
Mr. Chukwuma. Mr. Chukwuma.
So you're saying that a judicial officer is not a public officer?
A judicial officer is not a public officer, even though I'm aware of how the Constitution, how 5th schedule at its definition section defined a public officer to include so. But that is for purposes of when he must have left office. Not when he's sitting. When he's sitting, a judge, he must go through the earlier sections I cited. And so, that case does not derogate this situation now.
It's not on the same
force. It's not on the same force with the issue
CJ
going on.
is number 3 on the line as a public officer. Now, remember, when judges, that's judicial officers, are taking oath of office, apart from oath of office, they include that I shall abide by the Code of Conduct. That has gone to show that the Code of Conduct, every public officer, including CJN, who is listed number 3 on the schedule he was referring to, that must abide by the Code of Conduct. Now, just like the person in Lagos quoted, look, it is within the exclusive jurisdiction of CCT, reading the whole Constitution, it does not contemplate any other court apart from where judicial officer now has misconnected himself in judicial functions.
So moving forward now.
Can he try a president?
Moving forward, now that
Has he gotten an immunity?
Now that
CGN?
this has happened, for those who interpret this as contempt of court, citing the Court of Appeal decision, are they correct?
Please, can you say it again? What do you mean?
Because they say there's a Court of Appeal decision asking the CCT to stay action.
Yes.
Pending.
No, that can't be a contempt.
Because he went ahead.
Because it was given before, that was on the 23rd.
Even though that has not been determined, that's still a bone of contention.
Sorry?
When it was issued, it's still being contended.
Well, I think there's a presumption of regularity of a court order. The court order says it was issued on the 23rd. Then how can you now, prostate it and say, look, it was given either? Nobody. It's a question of fact to say that, look, it was given when the decision of Court of Appeal was pending or before. So it's a question of fact that must be determined.
Is that the case?
If they have any evidence, let them show it.
The issue is dated 23rd, but the question is, how come? You adjourned on your record to 28th, and the issue of whether you should grant ex parte or not was contested, and you agree that you cannot do anything. That is to the hearing of everybody, is on record. Nothing can be done until 28th, when the issue of
I don't think there's anything on the issue of the ex parte that was
Please
contested.
excuse me.
Yeah, but isn't jurisdiction, if you're challenging
Jurisdiction, can you now do anything else?
Of course. That you have to determine the matter of jurisdiction.
Let me tell you something.
But haven't you assumed jurisdiction if you went ahead and gave that ex parte?
No. You are missing the point. The issue of assuming jurisdiction does not take away the powers of the court, including its inherent powers.
No, but it affects the way things
let me land.
Because already it seems that the CGN was a bad egg by giving him this suspension.
Let me land. It is absolutely wrong for somebody to simply because they are challenging the jurisdiction of the court and then the court cannot do nothing. It's not correct.
No, but before the matter is determined, you can still do something?
Yes, of course.
Like
there are other interim things that could happen. If, for example, you are challenging the jurisdiction of a court, I told you very clear, even the provision of a statute makes it very clear that although you are challenging the jurisdiction of this court, before you do anything, calm. That means, I want to listen to me, please, because before a CCT trial is commences, there must be an order to commence trial. That's an order given. Now, he has been served with a court order. Then the court, what the SCJ is saying, look, before you do anything, come before the court, comply with the order, take a plea, and then proceed. Now,
hold on. The argument is
yes.
This ex parte order that was given, the president acted on it wrongfully, was rather tricked into acting to it because the processes had not actually finished.
How could he have acted wrongly?
How do you respond to that?
No. I believe, why can you say president acted wrongly? Look, a court order that is served on anybody, he has a duty to comply with that order. Now, listen to me. I think, to me, the president is dragged into unnecessary controversy which he ought not have been dragged.
Okay.
All he needs to do is, look, in complying with the court order given by the CCT, I hereby comply, direct the second Monsignor, in fact, without even make it saying I suspend anybody. He doesn't have to suspend him.
Okay.
The court has already asked him to
we'll come to that too, but
remember, there were 4 court orders earlier, of which the president was a party, the attorney general was a party. These are court orders as well. These are court orders from FCT High Court, 2 federal high courts, and then 2 courts, 2 different judges of federal high court, and then National Judicial Court, National Industrial Court. These orders are against the president, asking, don't do anything about the CGN anymore until the issues before them are determined. So why were those ones waved away? Why were those ones ignored? They were served on the president. They were served on the attorney general. So why? Do we pick and choose? If we pick and choose in nation building, we're inviting anarchy.
But if I were the president?
Secondly, thirdly, the issue now is, in a matter of this nature, ought we not be a little bit ought we not be a little bit careful? Ought we just dabble into this? Why was even, I want to ask one question. Why was this prescription warehoused?
Where do you mean warehoused?
Why was this prescription of CGN, why was it warehoused?
What do you mean by warehoused?
Yes, it's a good question. Is the matter I have taken before during the West electoral reform, when I said you can't use prosecution to beef up your position during the electoral period. That every prosecution ought to take place as at the time it happened. We're housing it and raising it up only during the election period. Is no longer serving the state, but the administration's interest. The issue said about the CJN, was it committed 2 weeks ago?
So is this about the 2019?
Excuse me.
Is this about the 2019 elections?
Yeah, let me respond.
Because we don't really have time.
Was it warehoused?
We don't really have time.
Why was it warehoused?
Let me respond.
The trial of NBA president, of what he said to have done in 2015, when the election petition was done, why was it warehoused?
Okay.
And done now.
You know,
is this a way to build
Let
a
me
nation?
respond like this. I least expect this kind of like response or reaction from our colleagues, particularly our senior colleagues. That look, you always look. People do look at things in Nigeria from political perspective. Is there any time that, unfortunately, law does not care whether it is election or non-election? Now, it's simply people trying to bring sentiments, politics, and sometimes some other things that extraneous in the orthodox. Now, the first question is that, has he committed them? I mean, is there any allegation against him?
Why didn't this administration detect before he was even appointed?
Does it matter?
Doesn't it matter?
No,
because the opposition, the PDP, for instance, is saying that purely this is an agenda towards the 2019 elections to rig it.
If I were him, I would have been grateful that it was not detected.
Let's put this way, because we're winding down now. Yes. We'll have less than 2 minutes or thereabout. Assuming, hypothetically now, the NGC, they're meeting. So when they do meet today, if they say, for instance, they do not recognize Justice Tanko,
yes,
what happens?
They can't.
Why can't
they can't? Because, one, they have to comply with the court order. The president has complied.
But there were 4 court orders before. There were 4 court orders.
Just quickly so we can bring him before we go.
The point is that, one, as the law is concerned, now there is an appointed acting Chief Justice of the Federation. So whether they like it or not, they must follow the court order. I know they will respect court order.
Quickly, please.
Mine is that there have been 4 court orders. We can pick and choose. And this one has to say that leave everything about this matter until I determine the issue before me.
All right, we need to go. Gentlemen, we've been speaking with Mr. Chukwuma Ume, Senior Advocate of Nigeria, former Attorney General for Imo State, and Dr. Nasser Aliyu, Faculty of Law, Barrio University, Kano. Thank you, gentlemen, for coming on this morning.
Thank you.
Thank you.
All right, we're back in a moment. Don't go away.